Messages from His Excellency the President.
I have a message from His Excellency the President, and it reads as follows. His Excellency the President has the honor to inform the Honourable the Senate that, on the recommendation of the Prime Minister, in accordance with Section 3(1) of the Ombudsman Act, Cap 8A, he proposes to reappoint Dr. Nigel Taylor, SCM, JP, to the office of the Ombudsman, established by Section 2 of the said Act. His Excellency further has the honour to seek the approval of the Honourable the Senate for the proposed appointment pursuant to Section 3(2) of the said Act. Signed by His Excellency the President of Barbados at State House, 11th of May, 2026.
Announcements by Your Honour, the President.
I have for confirmation minutes of our meeting on the 23rd of March, 2026.
Mr. President, I beg to move the confirmation of the minutes of our meeting held on Monday, the 23rd of March, 2026.
The question is that the minutes of our meeting held on Monday, 23rd of March, 2026 be confirmed. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. Those minutes are confirmed. Minutes of our meeting held on Wednesday, 4th of May, 2026.
Mr. President, I beg to move the deferral of the minutes of our meeting held on Wednesday, the 4th of May, 2026.
The question is that the minutes of our meeting held on Wednesday, May 4th, 2026 be deferred. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. Those minutes are accordingly deferred. I have some notices of absence. Senator Redmond, who is not well. Overseas are Senator Dr. Connell and Senator Malalu. Notice of late arrival, Senator Ryan Ford and Senator Janelle Odo. And an indication, just with the nation is not absent but will join on the online platform, Senator Slocum, who is overseas, will join on the virtual platform. That's it.
Presentation of petitions, presentation of papers.
Senator Cummins.
Mr. President, I'm commanded to lay the following documents. The Corporation Top-Up Tax, Designation of Competent Authority and Globe Information Returns Regulations of 2026, the Barbados Health Report of 2024, Annual Reports and Audited Financial Statements for Needham's Point Development, Inc. and Needham's Holdings Point Development, Inc. for the years ending March 31st, 2024 and 2025. Fourth, the Barbados Civil Aviation Authority Annual Report of 2025, the International Labour Convention 191, Safe and Healthy Working Environment Consequential Amendments Convention of 2023, and finally, the International Labour Organization ILO Convention 192, Biological Hazards in the Working Environment Convention of 2025, number 192, and related Recommendation 209, on Biological Hazards in the Working Environment Recommendation 2025, number 209.
Reports from select committees, questions to ministers, requests for leave to move the adjournment of the Senate on matters of urgent public importance, statements by ministers or parliamentary secretaries, personal explanations, motions relating to the business or sittings of the Senate moved by minister.
Senator Cummins.
Mr. President, I beg to move the suspension of Standing Order 45-2 for the remainder of today's sitting.
The question is that Standing Order 45-2 be suspended for the remainder of today's sitting. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. Accordingly, that Standing Order is suspended for today's sitting.
Introduction of bills.
Senator Cummins.
Mr. President, I have a number of first readings for today. I beg to move the first reading of the Maritime Areas Jurisdiction and Rights Bill of 2026, to move also the first reading of the Seafarers Bill 2026, the first reading also of the Civil Aviation Bill of 2026, as well as to move the first reading of the Criminal Gangs Prevention and Control Bill 2026. I also beg to move the passing, or should I say, passing of a resolution, to give notice of a resolution. Okay.
The question is that the following bills be read the first time: the Maritime Areas Jurisdiction and Rights Bill of 2026, the Seafarers Bill 2026, the Civil Aviation Bill of 2026, and the Criminal Gangs Prevention and Control Bill of 2026.
Notice of the resolution.
Senator Cummins.
Mr. President, I beg to give notice of the following resolution, a resolution that an address be presented to His Excellency the President approving the proposed reappointment of Dr. Nigel Taylor, JP, SCM, to the office of Ombudsman.
Public business, sir.
Just before I go to public business, I just want to acknowledge some young visitors to the Senate, most of whom I understand are related to the Leadership Institute, or charity, whichever is the last name, but leadership, and a guest of Senator Trim, I believe one, maybe a guest of Senator Goodrich. They don't have the names, so I want to welcome you, young folk. I hope you find today's sitting interesting. Public business is now the order of the day.
Public business, sir. Sir, before calling public business, the senators will recall that in December last year, this Parliament passed an amendment to the Constitution allowing the minister from either place to have right of audience in either house, and also allowing the Attorney General to have right of audience on any matter dealing with legislation. So to that end, the matter before the Senate this morning, the second reading of the Criminal Gangs Prevention and Control Bill, the Minister of Legal Affairs and Criminal Justice will exercise that right under the Constitution and will therefore move the second reading of this bill. So order number 650. In the name of the Honourable Minister of Legal Affairs and Criminal Justice, to move the second reading of the Criminal Gangs Prevention and Control Bill 2026.
It's my honor to welcome the Minister of Legal Affairs and Criminal Justice, as well as the Honourable Attorney General, to our chamber. We are very happy to have you with us. Minister of Legal Affairs.
Thank you, Mr. President. First, I also want to thank you for your pleasant accommodation, sir, and indeed your indulgence in allowing me to move the second reading, this bill, the Senate. Of course, I'm in company of some distinguished people. Indeed, we have some very senior politicians here that I recall when it was in 2003 that they had to battle with in the House Assembly. He won't call any names, but of course, it was a rough baptism, but indeed, I was able to weather the storm and I came through. But those days were, thank you. But those days, as the clerk of Parliament would say, those days were rough. And your back had to be broad the vote had to be brought. And even Mr. President would be able to, yes, you were there. Yes. And also Senator Walker. I will say that he was the chief person who, who felt licks on me. But of course, he had a staring look. And when he look at you, you know that when he got to speak, we expect some blows. And he was very vicious in his blows. But indeed still respect. Very, 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 you know, he showed respect for the traditions of Parliament, of course, and the standing orders. But I also want to, I moved this bill today because this bill is a landmark bill. I would say that is a landmark bill. There's nothing in on our books that speaks to gangs. There's nothing on our books relating to criminal law that speaks to gangs. And that is why I call this a landmark bill. I call it a landmark bill because it now offers a new tool to police officers and prosecutors to deal with law enforcement and, of course, to deal with the sudden upsurge in crime, firearm-related offenses, and the gang-related offenses. I want to thank the Advisory Council, Security Council, and also the Bar Association. Because this bill went through the Advisory Council, and I know that senators are here that who sat on that council. And we went through this bill along with other pieces of legislation coming out of Trinidad and Jamaica, sifting out the better parts of those pieces of legislation from Jamaica and Trinidad, and of course, other jurisdictions, to ensure that we have legislation that is palatable to the criminal justice system in Barbados. I want to say also, too, that the Advisory Council consists of members from various walks of life in Barbados, trade unionists, lawyers. We have a victim on that committee, crime. We had also people who were attached to the criminal justice system involved in that committee, so they were able to give varying opinions on the bill. The Bar Association, too. We sent it to the Bar Association, Learned Attorney General. We sent it to the Bar Association, we got back comments, and they supported the bill. They supported the bill. And I must say that the average Barbadian support this bill too. Don't look at me and smile. The average Barbadian support this bill. It is a fact, sir. And in fact, sir, the evidence is if you look at the editorial, Sunday gone, the editorial say that it is time that we have this piece of legislation. That is timely. He said that. It is timely because we cannot sit back. We must bring laws, stringent laws, to deal with this issue at hand. I must also say too that in 2025, the CARICOM heads in Montego Bay, they concluded that Caribbean governments, because there's a common problem throughout the Caribbean, and that Caribbean governments must look at placing stringent anti-gang laws as part of their agenda, and that we must treat it very seriously. And so, the background to this bill, and you know, only recently, I came across a statement made, and this was in court. And it was reported, a case, the state versus Gabriel Hill. And the learned trial judge, Justice Graves, yes, I can do that. I'll make a document in the House, Mr. President. It was Barbados' first case in which gang evidence was used in a murder prosecution. And he said, this is what he said, the learned trial judge. That is an urgent need to stamp out gangland killings before they further destabilize the society. This is Justice Charlie Graves. He went on further to say this, that it is important that these courts, by their sentences, do all that is within their power to assist in stamping out this gang tit for tat disease, call it a disease. Then he went on further to say, therefore, our gang associates must understand that the penalty is going to be heavy. There must be a strong deterrent factor in sentencing when it comes to gang murders. We must nip it in the bud, if we can, before it gets worse, he added. He said, what's also interesting, he rejected the argument that of the accused man youth. He said it is not old men that are joining gangs and shooting up people, but young men. This is what Justice Graves said in his sentencing remarks in that case. He said, it was a brutal murder, describing gang killings as grave and as a serious threat to society. That's what he said. So if there's any evidence or any cogent evidence or credible evidence that we need to bring this piece of legislation, we can just go simply to the case of the state versus Gabriel Hill and look at the sentencing remark of the learned trial judge. Coupled with the fact that we've had discussion with the stakeholders, and coupled with the fact that, of course, there's some other people too that supported it, but had one foot in and one foot out. By saying that I support this bill, but that you must go after the financial aspects of gangs, their finances, and how they acquire their finances through gangs. But you know, I always like to walk with evidence. And there's something called, in fact, let me put it down, and let me delve into it. We have the Proceeds of Crimes Act. And the Proceeds of Crime Act was a little too soft. But prosecutors used to use it to go after proceeds of crime. But in 2019, a bill was passed replacing the Proceeds of Crime Act called the Proceeds and Instrumentalities of Crime Act 2019. Yes, it's here. It's here. And this act dealt, or in fact, mentioned unexplained wealth. And if you talk about unexplained wealth, then you have to speak about a gang member who don't work no way, who sitting up on a block, but can drive a fancy car. but have the biggest house. And it must go, according to the Attorney General. It must go. Must go. Well, I've been troubled by Spanish station. But with the greatest of respect, Mr. President, greatest respect, Mr. President, I will move first. I will move first. Stop it. AM is not FM. Don't trouble me. Right. So the proceeds of that, so you have that legislative regime there ready to deal with what, I ain't calling name, of the person who was wrongful in or wrongful out. I support it. I support this legislation, but you know, within the same act, these with benefits from a criminal organization, these with person who decide, or let me put it simply, to put money in the gang, or a person looking to raise or get benefits, financial benefits or otherwise, from gang activities. So the law covers it. The law covers it. But I believe that my experience in the law courts and what they say will carry a little weight. I say a little, not enough, a little. And that when they speak about legislation, I guess I would have encountered those pieces of legislation in respect to indictments at the High Court. And it caused me to read. But I would advise the other person to just do some reading. I'll do a little reading. And that this legislation is an important piece of legislation. Important. And the question we must ask ourselves, why we need this legislation? And what does it demonstrate? What does it demonstrate? Sir, it demonstrates that the government intends to ensure that the rule of law obtained. Secondly, this legislation is about dismantling gangs, preventing those young persons from being recruited to criminal organizations. Protecting communities and ensuring public safety. And also ensuring public confidence in the criminal justice system. That's what this bill demonstrates. And this bill is sending a signal, respectfully, Mr. President, to organized gangs and want to be organized gangs as basically a deterrent, sir. And the reason I say deterrent, sir, the offenses under this bill, sir, they are all indictable. And when I say indictable, sir, all of these matters are treated at the High Court level, sir. You appear before a magistrate. But your trial cannot be done before a magistrate. Your trial is done before High Court judge and jury. And that is why, sir, that we had to put that in this bill to show that we are treating this matter on a very serious level. It gives police officers, sir, and law enforcement agencies, sir, another tool, sir, to tackle this type of behavior, sir, and type of criminal offense, sir, in this country, sir. Sir, I want to say, sir, that we have to get back our community, sir. We have, sir. We have to get and save our community, sir. You know, I want to say, sir, too, that this bill by itself alone cannot and will not solve the issue, sir. This have to go hand in hand, sir, with the crime prevention measures, sir. Have to, sir. Is a tool? Yes, sir. It's a tool. An additional tool. But the crime prevention program of this government must go hand in hand, sir, with this bill, sir. And, sir, I recall, sir, that the government announced what we call the Chapman Lane Challenge, sir. Chapman Challenge. We call it lane because my concept. I recall too, sir, that only recently, sir, the government set out, sir, to meet and to put funds, sir, in faith-based organizations, sir, to work in communities, sir. Work in the community, sir. Work with programs, sir, with young people, sir. And that governance arrangements were put in place, sir, to ensure, sir, transparency, sir, and accountability, sir, in relation to funds allocated, sir, to this program, sir. But I say, sir, that we have, of course, to address the root causes, sir, of crime, sir. By way of community development, sir. We're looking at education system, sir. And of course, looking, sir, at our social services, sir, to ensure, sir, that they touch, sir, those persons, sir, who are at the brink, sir, of the criminal justice, sir, or a person who comes out the criminal justice system, sir, because we also have to look at offender monitoring, sir, and also rehabilitation, and also reforming individuals, sir. Gang leaders, sir, go after the unemployed, those who come from dysfunctional families, sir, those who, sir, are the subjects, sir, of drug abuse. They're easy, sir. And I'm saying this, sir, from the point of view of that a gang leader will go in a community and seek out these unemployed youth, seek out a youth who is troubled, sir, by the use of drugs or substance abuse. I want to make this point, Mr. President. In my experience, when a man is convicted, sir, by a jury, sir, and before he's sentenced, sir, under the Penal System Reform Act, sir, there must be what we call a pre-sentence report, sir. In that pre-sentence report, sir, many times when we read it, you look, age 13, giving trouble at school, sir. At 14, beat a teacher. At 15, sir, marijuana use, sir. At 16, sir, got kicked out of school. This is a report now, sir. But you know, in that report, there's no social interventions that come in there to help this young man. And you wonder, why? And then when you look, sir, because they all normally have a part, family background. When you look at the family background, sir, tremendous issues. And so we have to tailor our crime prevention program, respectfully, Mr. President, to ensure that it involves early social interventions, sir, so we can save some of those young people from getting involved in the criminal justice systems. What we have to do. And, sir, I am an advocate, sir, of the return of the drug court. Because many of the offenses is a result of drug dependency. And sir, if we can bring that, sir, as part of our criminal justice system again, sir, I believe, sir, we will see results, sir. Further, sir, I am of the view too, sir. I think I have 2 hours, sir, so I will go into the bill shortly, sir. Mr. President, sir. Mr. President, we look at the accused and we look at the convicted person, sir. But you know what we don't look at, sir? The victim. And the victim family. Because anger will now step in to that young man or young girl who just lost their father, lost their mother as a result of gun violence, or a result of gang activity, sir. And they too might move towards a life of crime. So the social intervention must be all-encompassing, sir. Not only the convicted person, but also the victim too, sir, respectfully, sir. President. Sir, I'm a strong advocate too, sir, of offender monitoring, sir. I'm a strong advocate, sir, of rehabilitation too, sir. And that, hopefully, and very soon, we will put things in place, sir, to deal with the aspects, sir, of offender monitoring, sir. I say that, sir, because it's a fact that some persons who are out on bail commit other offenses, sir. There are some persons, sir, who might be a first-time offender, sir, but we still have to monitor them too, sir. We still have to monitor them. And we have to look, sir, holistically, sir, at our criminal justice system, sir. And I say this, sir, because this bill is part of the legislative agenda, the robust agenda, sir, of this government respecting criminal justice system, sir. Part of the criminal justice system, sir, there was an increase in judges, sir. Secondly, sir, there was an increase in prosecutors, sir. Thirdly, sir, there was a comprehensive bailout, sir, passed, sir, that places further obligations, sir, on applicant for bail, sir, and the state, sir. There were serious amendments, sir, to the Firearms Act, sir, placing stiffer penalties, sir. And, sir, that harboring is an extremely serious crime, sir. It is an obstruction to justice. It is showing contempt, sir, for those stakeholders, particularly the police, who go out there and work hard, sir, to ensure that persons are apprehended, sir. I can define it now. I can define it. Sir, I will go through, sir, details, sir, of harboring, but it will also give examples, sir, of what constitutes harboring, too, sir. According to the bill, sir, harboring, sir, means to give shelter or refuge to the person and to encourage or support the person, whether implicitly or explicitly, in committing gang-related activities. That's the definition, sir, of harboring. The definition of harboring. So if, sir, you have knowledge that a person is engaged in gang-related activity, is a member of a gang or a gang leader. But the critical element in this offense is knowledge. It's knowledge. So if you open your house, having knowledge that this person is a gang member or gang leader involved in gang-related activity, if you open your house and put him in a bedroom, feed him, lock the door next so the police, nobody in the neighborhood can see or know that you're there. Take food for him. Or even if you rent an apartment and allow him to stay at the apartment in your name and give him a key, having knowledge that he's wanted by the police, that is harboring. That is harboring. So you can't get there or use a defense and say, well, I don't live there. I only just rent the apartment. I only just rent it. But I don't live there. I rent the apartment. But you're giving him shelter. You're giving him shelter. And so that is why we are treating in this legislation the harboring. And if you look at the penalties to attach this, at a very, very, very serious level. But the other point, with respect to harboring in this bill, that if the person is related to that, whether it's a child, and you harbor your child having knowledge that person was involved in a criminal offense. If there's some attempt by you to rehabilitate or reform that person, that is used as a mitigating factor when it comes to sentencing. That's so harboring is indeed a very serious offense. And in this bill, that is why we said in section 21 that bill, like firearm-related offenses, if you want bail for an offense under this act, you have to go to the High Court. You have to apply to a judge in chambers to get there. Similar to firearm-related offenses. Similar to the Firearm Act. Section 22 of the bill. An application for bail for an offense committed on this act shall be made to the High Court, subject to provisions of the Bail Act. In this bill. And we place in this bill that offenses against important stakeholders in the criminal justice system, that if you, let me read, offenses against a judicial officer for the purposes of this act. A judicial officer includes a judge, a magistrate, a member of any other government agency directly involved in the management of a case involving matters under this bill. And the persons who threatens, assault, or engage in any activity aimed at deterring a judicial officer from the execution of his functions under this act commits an offense and is liable on conviction or indictment to imprisonment for not less than 30 years, 20 years, and not less than 30 years. And this is important. We must protect our judiciary. It's an important part of our democracy. And gangs have tentacles. And even in this bill too, even to intimidate or to interfere with a juror is also a serious offense. I always say that our system trial by jury, we only had one blanche. Only had one blanche. In the case of the Concept Bay case where a juror, two jurors were approached by accused men. It's a reported case. They were given some money to bring back a verdict in their favor. But the police officers, investigating officers found out, and they were brought before the court for perverting the course of justice and obstructing justice. And they got a custodial sentence. So they came to court. They came to court to sit on the case and ended up being an accused. So they turned from juror to an accused and end up in prison. I think they got about, between 4 and 5 years or so. That's the only blanche. So this bill protects our criminal justice system too. And it protects our criminal justice system by some very strict penalties. Some very strict penalties. And I want to say also too, that this bill have in it protective mechanisms. Because we will hear, oh, they're going after the people. They're going after the people in the working class districts. The people in the plain and all, they're going after them. But this bill states the community in which a person resides shall not be a factor in determining whether that person is a member of a gang. So it's protective in here. Section 4(2) of the bill. It's in here. Right here. Further, with respect to this bill, there are safeguards built into this bill with respect to police powers. The bill says that police can arrest without warrant and hold you for 72 hours. But you know what the safeguards in this bill? It places the obligation on the police officers to make a record of every single interaction between the investigating officer and yourself, and they have to give reasons for the detention. But you know what the bill further says? That the police officer can review the grounds of detention, and if he believes that, look, these grounds are reasonable, we can't hold this man in here for no longer, he has the power to release him. And vice versa, if he believes that releasing this man will prejudice the investigations, or will cause harm to a witness or impact on the case overall, he can then apply to further extend the person's stay at the police station. But you know, built into this bill too, that he can apply to a judge for ex parte order, but there must be reasonable grounds, because you're impacting on somebody's rights and freedoms. So there must be reasonable grounds. But also gives power to the suspect who is in custody when the court grants the order for further extension. It also gives power to that person to apply to the High Court to have that order discharged. I say that because this section incorporates fairness and transparency and accountability for the agents of the state, meaning the police officers. Meaning the police officers, sir. And sir, someone would ask, what is a gang? And this bill defines what is a gang, sir. It defines what is a gang. But I did some research, sir. I'm from the Caribbean indulgence, so I just want to, because prosecutions under gang bill legislation throughout the Caribbean is not an easy task, sir. I'm from the Caribbean indulgence, so I want to refer to a case coming up to Trinidad and Tobago. I'll make a document, of course, sir. Two Prophet King, sir. Reno Sampson, Keon Sampson, Garfield Joseph, and the Attorney General, sir. But what is instructive, sir, in this judgment, sir, is at page 7, sir. And this is what the judge said with respect to gang legislation, sir. He said, it is readily apparent from these provisions, this is Trinidad provisions, this is important material to our legislation, that proving gang membership in a court of law is no slam dunk, sir. It requires a careful compilation of the evidence showing how the gang is organized, how the gang activity is perpetrated through gang members, and their respective roles in such activities. Evidence at trial must be carefully laid to allow the nexus between the gang, the members, and the activity. In a case where the gang-related activity relates to narcotics, evidence of actual sales of the narcotics is required to prove the gang-related activity. Where surveillance without more, it is not simply, sir, mere surveillance without more may not suffice. It is not enough to simply observe the accused making interactions with other persons. The evidence must be that narcotics were sold by the accused to someone. This includes proof of exchange of money and the actual price paid. Undercover detection may be necessary. The best evidence must be that of a former member of a gang who had direct knowledge of the activities. So, what this is saying too, sir, and it will mean, sir, that there will have to be training with respect to our police officers, training with respect to prosecutors, training with respect to judicial officers, sir, with respect, sir, to this piece of legislation, sir, which is really a specialized piece of legislation, sir, that deals, sir, with certain groups and organizations involved in criminal activities, sir. And, sir, I also want to deal with recruitment, sir. I said, sir, from the start, that if, sir, that we could bring programs, in fact, only yesterday, the One Family program was extended, sir. That One Family program with this government, sir, is it is an excellent program, reaching into dysfunctional families, reaching to those in need and to vulnerable people, sir. Those types of programs, sir, form part, sir, of the crime prevention program too, sir. And that is why, sir, we had to place, sir, the offense of recruiting, sir. That if a gang member of gang leader recruits someone, sir, and that if they go near a school to recruit a child, sir, and even if they recruit somebody who's not a child, there's a difference, sir, in the penalties, sir. The difference in the penalties respect, sir, to the child. It carries a higher penalty, sir. The Learning Attorney General, sir, will speak to the specific, sir, the penalties, sir, attached there, sir, to this offense. Gang, sir, as I said before, gang leaders and gangs go after young men who are vulnerable, that they can recruit them, sir. And how, sir, to place in this, we had, sir, to place in this legislation, sir, the offense, sir, of recruitment, sir. Further, sir, if, sir, you use a police uniform or anything that attacks, sir, to a law enforcement agency, sir, and you use that to commit a gang-related offense, that too, sir, carries a penalty, sir. That too carries a very serious, serious penalty, sir. Tipping off too, sir. Tipping off is also an offense under this bill, sir. So if you believe, sir, that you have knowledge that an offense is about to be committed by a gang or a criminal organization, and you use whatever means it is, sir, to tip off that person so that they can evade justice, sir, or avoid justice, that too is an offense, sir. And it carries, sir, from very stringent penalties too, sir. Criminal indulgence, sir. All in all, sir, Mr. President, sir, that many mention fairness, sir, in this bill, sir, carries or gives power to a judicial officer, too, sir, to vary the sentence, sir, to vary a sentence. So although, sir, that we have strict penalties, it does not take away from the discretion of a judicial officer, sir, to vary a sentence, sir, in relation to the facts. Because each case, sir, and each facts are different. They're not the same. And so it gives the discretion, sir, gives back certain discretion to a trial judge, sir, or sentencing officer to vary the sentence, sir. But, sir, this piece of legislation, sir, forming part of a criminal justice system, it means that we have to improve our criminal justice system in terms of treating the cases, sir, in a timely manner, sir. I can say, sir, and you know the Attorney General, sir, could attest to this, that very shortly, there will be criminal procedure rules coming into play that would impact, sir, on backlogs, would impact, sir, on speedy justice, sir. I say speedy justice, sir, because our system, we have been described by the Caribbean Court of Justice, sir. Our system has been described, sir, as riddled with delays. Riddled, sir, with cases that take too long, sir. And that I can say to you, sir, that when we place in this legislation that these matters are indictable, sir, that the criminal procedure rules, sir, rules that come in, will place the onus on the stakeholders, particularly the arresting officers and police officers, sir, to have the files ready, to have statements ready, sir, within a particular time frame, so that there will be no delays, sir, with respect to matters under this bill, sir. And that, sir, that if we want, sir, to have the impact or effect of this bill, sir, we need, sir, a whole society approach, sir. That is not the government alone. It's not the government alone, sir. And thank you for that nod, sir. And that we need community leaders. We need youth groups, sir. All the community churches too, sir, to play their part, sir, in dealing, sir, with this issue, sir. So this legislation alone cannot solve the issue. Our crime prevention program, sir, is in place, sir. It's in place. And there's a reason why I say that. There's a reason I say that. But I believe I have the right to come back, sir, Mr. President. But I can speak, sir, about a number of programs, sir, that form part of the criminal prevention program of this government, sir. I can list them out, sir. I can list them out. All I can say, sir, is that we have, when this is passed, sir, we will have to embark, sir, on a public education program too, sir. And we have, sir, to go into the schools. We have to go into community groups to say to young men and even women, instead, sir, of joining again, join the church, go to Sunday school, join the landship, join the sports club, whether it's St. Catherine's Club or Empire Club. Go to football instead, sir, of being on the block and being teased out by a gang leader, sir. And being teased out, sir, by offerings from a gang leader, sir. Because we have, sir, a duty to get back our communities. We have a duty, sir, with respect to public safety. We have a duty, sir, to ensure, sir, that the rule of law is obtained, sir, and maintained. We have a duty, sir, to say and to ensure that our criminal justice system, sir, has all the tools, and the stakeholders too have all the tools to ensure that justice is not only be done, but is seen to be done, sir. As I said, sir, the learning the AG, sir, will go through the clauses one by one. But there are other offenses too in here, sir, that, and they touch on, but they know, my learned friend will touch on those offenses too. Sir, Mr. President, sir, respectfully, sir, I move that this bill be read the second thing, sir.
Thank you very much, Honourable Minister. Senator Walters. Senator Walters.
Thank you, Mr. President. Good morning. Good morning. Good morning to all. Mr. President, I did not anticipate today that I would have been responding to the Minister of Criminal Justice. But I'm happy to see him. I know a few minutes ago he would have been in another place and singing another song. But, Mr. President, this is not a new debate. This is not a new debate. And as you've heard from the Minister, with additional legislation to come, the debate will continue around crime prevention in this country. Crime has been discussed rigorously for the last 7 or 8 years, Mr. President. And it has become specifically a hot topic because of the lived realities that we face today in this country. And it has intensified over the last 2.5 years specifically. Because, Mr. President, for the last 18 to 24 months, we have had at least on average 1 murder a week in this country. On average, 1 murder a week in this country. Last week, Mr. President, while this bill was being debated in the other place by the same minister, if I recall correctly, there was a murder on that same day. 2 nights ago, Mr. President, there was a murder in this country. So this topic, this has been a hot topic. It has been very relevant. And the Democratic Labour Party has been a part of this conversation and will continue to be a part of this conversation, Mr. President. So, Mr. President, it's easy to support this bill because, Mr. President, the former leader of the opposition called on numerous occasions for anti-gang legislation in this country, Mr. President. For numerous times, starting at least 2 years ago. Not yesterday, Mr. President, not last week, not last month, not last year, more than 2 years ago. The leader of the opposition was calling for the government to get aggressive with the crime situation in this country by calling for anti-gang legislation. Mr. President, they also said, this government, that crime is not a political issue. And we in the Democratic Labour Party want to make it a political issue. We have heard the statement, Mr. President. But, Mr. President, if the Democratic Labour Party or any organization in this country had called for legislation to help address the crime situation in this country, and the government ignored them, who is playing politics? The government ignored the numerous calls because they did not want to give any credit to another entity, especially the adversary of the political party called the Democratic Labour Party. 2 years ago, Mr. President, 2 years ago. Oh, sorry, Mr. President. But, Mr. President, the DLP, the,
Honourable Senators, we become a little bit too busy in here. Let me hear Honourable Senator Ryan Waters, please.
Thank you, Mr. President. Thank you. The DLP, Mr. President, and the opposition, and I don't think any right-thinking Barbadian has blamed the government for the crime situation or the murder rate. But what we guard against is the notion that they do not take the responsibility for controlling it, Mr. President. In July of 2024, the Democratic Labour Party formed a commission on crime to contribute meaningfully to the conversation around crime prevention and attacking the crime situation that is spreading out of control. And this commission, Mr. President, was chaired by an attorney at law and a criminologist. A retired senior police officer also was the deputy chair. It also comprised of youth policy directors, educators, pastors, military personnel, and trained psychologists, Mr. President. That is a party that took and takes dealing with the crime situation and the murders and the guns in this country, illegal firearms in this country, serious, Mr. President. We formed our own commission so that we could contribute meaningfully to this dialogue and this discussion. In September of 2024, the government hastily put together what they call the National Advisory Council on Citizen Security. Mr. President, the current Minister of Criminal Justice declined to participate in the DLP's Commission on Crime and opted to participate in the National Advisory Council on Citizen Security. Mr. President, a year after, in July 2025, the Democratic Labour Party shared with Barbados, and I'm going to make it a document of the House, a 148-page document called A Blueprint to Rescue a Nation that dealt, Mr. President, succinctly or comprehensively with identifying the issues and drivers of crime and laying out practical solutions to tackle the crime situation in this country. In a year after, Mr. President, and I said I will make it a document of the House. What are the results of the National Advisory Council on Citizen Security? In July 2025, about 10 months later, all we are told, Mr. President, is that the chairman resigned. The council was too large. The members were unable to meet, Mr. President. They were understaffed and they did not have a secretariat to carry out their duties, Mr. President. And the perception was that it was an opportunity for persons to make some money. Mr. President, the deputy chairman, Mr. President, is now the Minister of Criminal Justice. That is what we have to show.
Honourable Senator Walters, I will not allow you to impute improper motives to public-minded citizens who agree to serve on a government committee. There was no salary, no stipend. Some were way down in the life of the committee. The Office of the Attorney General provided a very small stipend. I don't remember the amount, but far less than what members serving on a secondary school board will receive. But none of that was raised as part of the reason for joining. That was a decision unilaterally made by the Office of the Attorney General maybe 6 months, a year after the fact. So to suggest that public-minded citizens join this as an opportunity to make money is really not good. You will want to withdraw that and move on. They're not here to defend themselves, and they therefore should defend them as all good persons of honor. Please continue, Senator Walters.
Thank you, Mr. President. I support what you're saying, and I'm not saying that they had improper motives. I'm saying that the perception, it was noted from a person on the committee that the perception was that it was an activity where persons can engage in making assurance.
But this is not, Senator Walters. This is neither a house. There's a house, but not a patio of a house or a web shop. It is not the place for a rumor to be entered into Hansard, and therefore to be given the weight of considered thinking. So there's another place to deal with that. Anybody's perception, he say, she say. I'm just saying, you're making good points. Stick to the high ground. Do not impute improper motives or opportunism to citizens who have served. What I would not want is for citizens who choose to serve on a committee to deal with education or road works or youth policy to be afraid that at some point in time, someone may suggest that they're doing it for pecuniary gain.
Yes, Mr. President, thank you. Mr. President, the point being made.
Mr. President, I would like to ask that the comments be struck from the record. On a point of order, Mr. President, I would like to ask that his comments be struck from the record.
I've already instructed Senator Walters to withdraw the comments, and when they withdraw, they're struck.
He has not withdrawn them.
Senator Walters, please indicate you're withdrawing the comment, and we'll move on from there.
Mr. President, I withdraw those comments.
I thank you, Kenny.
Although misunderstood, but I withdraw the comments, Mr. President. Everybody's getting sensitive all of a sudden. But the reality is, Mr. President, that the National Advisory Council on Citizen Security has not produced a document or any report to the nation that gives us the confidence that they had executed any duties. What we heard from the minister in the other place during his deliberations was that the Advisory Council report, that the report was made as relates to the anti-gang legislation. It was not made a document of the House, so we cannot review it to say what it contained. But the point I'm making, Mr. President, is that...
I raise an point of order, sir. Exercising my prerogative.
Yes, Attorney General.
The honourable member is misleading the chamber. Sir, nothing prevents the honourable member from properly preparing, reading and researching before he comes here. Actually, we encourage him to. If he waits until documents become documents of the House to read them, then he will always be unprepared. The fact that the report that formed the basis for this and for a lot of the provisions of the anti-gang legislation, sir, was not made a document of this chamber does not mean it was not published, circulated, and considered widely. So I'm asking the member, please, to not suggest that for anything to have authority, that it must be a document of the chamber. That's for the purpose of the record of this chamber. It does not affect the average citizen in reading a document, and it certainly does not affect him in preparing before he comes here.
Mr. President, I would not take on the personal attacks about preparation. My point is, Mr. President, that the National Advisory Council on Citizen Security, as far as I am aware, as far as the public is aware, has not presented a report of what they have conducted over the last 2 years in terms of their research, their findings, their solutions, Mr. President. And I'm drawing a contrast to the Democratic Labour Party, who has taken this situation very seriously and who has formed a committee prior to that committee and has been able to present a comprehensive document that gave solutions to dealing with these issues. I'm just making a reference, Mr. President. I'm not talking about the drafting of this specific legislation. I am speaking specifically, Mr. President, to the crime situation and the fact that the National Advisory Council, on which the minister admits that he leads, has not produced anything substantial that we can consume, Mr. President. But I continue.
And if I can assist you, Senator Walters, please be aware that an advisory committee advises the entity that appoints it. So the terms of reference of the advisory committee will advise the Minister for Crime Prevention, on strategies and so on to improve citizen security. Several reports, as far as I'm aware, have been made on matters ranging to the preventive, to the curative, but they are sent to those whom have appointed. The decision to publish or not to publish will be in the realm of those who have appointed. So you compare apples and oranges. The fact that the other commission was empowered and developed to make a public report, that's fine. They're both valid, and therefore you really should not be harsh on an advisory committee that has advised the entity that appointed it, but has not chosen at the same time, in parallel, to issue its advice publicly. That certainly would not be good form, and I believe there are other examples of similar action recently which have not gone down well. Their advice that should have been private has been entered publicly. But please press on.
Mr. President, thank you. I think you're really assisting the minister here. But Mr. President,
I'm only assisting the facts.
yes, that's fine. Mr. President,
I'm not assisting the minister. I'm assisting you because, you know, so I take the point you're making, but I just saying from a factual point of view, these are the facts. But I'm not assisting the minister or anyone.
but Mr. President, this is not an exercise for me in personal attacks, and this is an exercise, Mr. President, because it is something that has continued to affect communities and livelihoods in this country, and it requires a certain level of maturity when it comes to deal with these issues, and political maturity as well. And my substantive point, Mr. President, was that the Democrat Labour Party has been a mature political organization, lending its ear to the conversation, giving research, giving suggestions, and also in the Parliament as an opposition was able to call for anti-gang legislation, was call for strengthening the Bail Act, was to call for other pieces of legislation to help arrest this crime situation for the benefit of all, Mr. President. So, Mr. President, why I start here, Mr. President, is because I think it is important, because if the government is now saying today that this is an important piece of legislation, a landmark piece of legislation, they expect that we should get some results in terms of arresting the crime situation, maybe a short or medium time, I don't know. But I'm saying that because it is so important, it should have some almost short to medium term impact in how we address the situation of crime. That is a reasonable assumption. And if that is a reasonable assumption, Mr. President, the fact that it was called 2 years ago, if it was brought earlier, Mr. President, maybe we would have seen a stemming of those interactions, those violent interactions, those shootings in public places, and those deaths and murders that we are seeing today, Mr. President. That is all I am saying. So, Mr. President, as I said, Barbadians are concerned, and they've been weighing in on this, and the Democrat Labour Party has weighed in a mature manner. We have represented carefully what we want, what we think the government can use to assist in their crime prevention efforts, and we support this bill because we have also asked for the introduction of this bill in both chambers, Mr. President. But, Mr. President, we want to caution, while we support the bill, we want to caution the government. And I think there was some clarity being made by the minister, but I want to refer to some comments that were made by the Attorney General when he said that if you associate with a gang, you will go to jail, Mr. President. And the caution is from the use of the word association. Because when one hears the statements, we have to also consider immediately the realities of many in terms of the livelihoods in Barbadian communities. And what do I mean by when I say that, Mr. President? In densely populated neighborhoods, people grow up together, attend the same schools, play on the same sporting teams, attend the same churches, may be related by blood, marriage, or lifelong friendship, Mr. President. A mother may have a son, Mr. President, that has never committed a crime or an offense, and have another son who has gone astray, Mr. President. A young man may be avoiding criminal activity, but may be sitting at a community shop 3-4 days a week, Mr. President. A shopkeeper, a coach, a pastor, a teacher, a community activist, a neighbor may interact daily with individuals who are known to the police. So association in and itself and of itself should not be criminal, Mr. President. So while some clarity has been brought by the minister, the words of the Attorney General had suggested otherwise, Mr. President. So we must not create a climate where ordinary citizens fear that proximity to wrongdoing will be treated as participation in wrongdoing, Mr. President. So we know, Mr. President, that legislation alone will not address the issues that we face today. Passing legislation will not address it alone. Enforcement will address it as well. And that's an important point for any legislation, enforcement. And the LP's position is to dismantle the gang networks, not merely lock up the boys on the block that are associated or that are gang members. Dismantling the gang networks. So when we talk about the sources of finance, that's what we're talking about. When we talk about who's funding the illicit trade, who's paying to get the guns into Barbados, who's paying to bring in the drugs, who's paying to give somebody a gun to go and shoot another person, we're talking about cutting off the head of the lizard, Mr. President. And no. I use my own analogies. You don't use the analogies that I use. The point is, Mr. President, that at the end of the day, the minister is referring to a person who is talking about dismantling the gang network, looking at the source of funds, and not only going after the little boys on the street. The minister also alluded to the legislation which he referred to, what was the legislation? The Proceeds and Instrumentalities Act. No, Mr. President, I don't think it's referenced specifically in the legislation. It's an independent piece of legislation. Right, it's not. I'm not an attorney, but the question is, can the legislation or can we go after, is it easier to go after those persons that are financing criminal activity if there is a kind of a collaboration in terms of insertion of elements of that bill or that act within this criminal gangs bill? That is the question. Can the bill be strengthened if there are specific elements of those bills, of that bill in terms of the Proceeds and Instrumentalities Act that are either inserted or drawn on specifically so that when a person is, for example, taken into custody or charged or convicted of being a gang member, that there are other actions that can happen very fast, swiftly, to deal with getting to the source of the funds or the financing of the gang activity? That is the genuine question as it relates to dealing with the source of funds and the financing of criminal activity. So I'm sure it is known, Mr. President, that there is the Proceeds and Instrumentalities Act of Crime Act. I'm sure it is known. But can there be better harmonization of the two to make it more effective in going after those persons that are financing the criminal activity? But even under that act, passed in 2019, is it working? What are the results of that act? How many criminal organizations have been investigated and financially dismantled since 2019? How many of those luxury vehicles that the minister referred to have been seized? How many gang leaders have been stripped of their assets that fund the criminal activity? So part of this is also about the results of some of these legislation that has been passed. Are they working? Are they working for the purpose that they were intended to, Mr. President? So it is fine to draw the references to the legislation, but how do they collide with each other? And then what are the results since 2019 with going after some of these people that are financing criminal activity in this country? So, Mr. President, I used the analogy of the lizard, because as a young boy, we used to capture lizards, and then we would cut them up, unfortunately. If you cut the tail, they wiggle and they go. If you cut the head, they're gone, they're dead. And the point is that we cannot focus then on only picking up the guys on the block, the young fellas, the youth that we are speaking about, that are going to carry out the activity, that are going to follow the orders. We have to cut off the head so that the criminal activity dies. The gang networks have our communities under attack. Our young men being murdered every week. Innocent bystanders murdered as well. People are living in fear, Mr. President. And if we don't believe it, something is wrong. So, Mr. President, the option is to cut off the head. Get those who are financing the gun trade and illegal activity. We must remember, Mr. President, that the head of the lizard, so to speak, is really the young man standing on the corner. He's not importing the guns. He's not financing the drug shipments. He's not laundering large sums of money. Those activities require money. Those activities require organization. And those activities require leadership, Mr. President. So if we are serious about dismantling the gang networks, we have to attend to the people who are financing these activities and who are profiting from criminal activity in this country. Mr. President, we cannot have a conversation about crime and the crime situation without support for the police service, Mr. President. And our officers are at the forefront every day addressing criminal activity, confronting armed criminals now more than ever, investigating murders. They're working extended hours. They have significant challenges that need to be addressed, Mr. President. We need to fix the police service. And no anti-gang legislation can be effective if the men and women charged with executing and enforcing it are overstretched, under-resourced, or operating in conditions, Mr. President, that do not reflect the importance of their work. But, Mr. President, only a few weeks ago, Mr. President, the police service, one of the spokespersons for the service, was referring to 12-hour shifts that they have to work, the kind of burnout that is happening in the force, the uncertainty of the rate of pay for things like overtime, delayed payments with the said overtime, Mr. President, and the conditions of the facilities that they have to work in and the conditions of their service generally. These are important issues in the fight against crime that go hand in hand with this Criminal Gangs Prevention and Control Bill, Mr. President, because it is going to be passed, but then the set of persons have to carry out the duties to ensure that it is effective, Mr. President, and that is the police service. And funny enough, on my way down this morning in the vehicle, I heard another news story that said that the police service again was concerned about the wages and the overtime and the burnout, and that is not really getting addressed. So I know the minister is new to the party and to the government, Mr. President, and he needs to pay some careful attention to the police service, Mr. President. And I also heard, Mr. President, in that same news story this morning, that there's some rumbling in the beehives. So I listened intently. I was wondering what's happening in the beehive. I wondered if the rumbling was because there were people now included in the senior way that have everybody else upset, Mr. President. But that story didn't come, something else came, Mr. President. But the point I'm making, Mr. President, the point I am making is that the police service must not go unnoticed. The issues have been going on too long. They are widely known, and they need to be addressed, Mr. President. They need to be addressed. This government has been boasting about being innovative and being fast to do a lot of things first. So they have to do some things at a much faster pace to deal with the situation with the police service in this country. Mr. President, we have the legislation, we have the police service, then we have what I guess you would consider the all-of-country approach. And the government has rolled out what they call the peace program. And we must discuss this, Mr. President. This is one of the central points of the government's program to help address the crime situation in this country. It is important to have a set of programs that deal with the social side, the social elements of the communities. Things that will help deter our young people or not so young people from joining a gang network or even just doing things on their own, Mr. President, that are of a criminal nature. So we acknowledge, Mr. President, that what is required is an all-of-society approach. There's no contention there. And the government has acknowledged its role in intervention by creating the peace program. So if it has acknowledged its role by creating the peace program, we need to see some results coming out of the peace program. Do not turn this into an attack on the persons in the peace program, persons on the other side, Attorney General and Minister. It is not an attack on the persons doing whatever they're doing now. It is how can we improve what they are doing so we get better results, so that we can go on a shop in the evening and have a beer and not have to worry if somebody's going to drive by and spray the place. We can go and attend the karaoke and not have to worry somebody can come up and shoot through the crowd. These are realities, Mr. President, right? So it is very important, Mr. President. It is very important that we get results. For that reason, but also for the other reason where the government, Mr. President, and the taxpayers are putting financial resources at the disposal of the program. Two main elements. Again, Mr. President, they will probably come at me. But what are the results of this program? I spoke about the realities of the Advisory Council, as I see it. What are the results of this 3-year program? 3 years, Mr. President. And what we know or what we see publicly, what we know publicly, Mr. President, as the former Attorney General, is on record as admitting that there were mistakes in the crime prevention program. He admitted that funds were dispersed to persons who were involved in criminal activity at the time. That's what we know. We also know, Mr. President, that the person who was in charge of the program is no longer with the government, and I'm not even sure if he's no longer with the party, Mr. President. But, Mr. President, millions have been spent over the years in the National Peace Program. Taxpayers are asking questions about the results. We do not, and we're not talking about, and we don't expect miracles, Mr. President, but we expect that there is some progress in terms of achieving what objectives you set out to do. Mr. President, no serious person expects a program of this nature to eliminate violence overnight. So I'm not going down that line. I am saying if there are specific programs that are being executed, give the public the confidence that the programs are getting somewhere. They are breaking ground. All or most of what the public sees, Mr. President, are cricket matches, Mr. President, and domino competitions. And there is some value in that. But as I understand it, Mr. President, the peace program was to get into the communities to work with at-risk youth. And Minister said it this morning, Mr. President, that it is the young boys, not the old men, that are involved in the activity. But who's playing the cricket? Are the at-risk youth playing the cricket? And then what happens after the 4-week cricket competition? This is a genuine question. These are real situations. There's a place for that sort of community engagement. Nothing is wrong with a member of parliament to go and hold a community match for 4 weeks. Doesn't even have to be a peace program. The peace program needs to have a very specific purpose of intervention for results of those at-risk youth, the guys that can leave school in August and September. And not even be targeted specifically, but find their way on the block. Themselves find their way on the block. Mr. President, these are realities. So, Mr. President, I think the government owes it to the public to give us an update on the peace program. Tell us what you're doing beyond what we see on the surface, because there has to be some deeper intervention that is happening in our communities. Mr. President, it would be good to have an idea of how many young people are being targeted and are being diverted away from criminal activity. How many are returning to education? How many are talking about at-risk youth? How many have gained skills? How many have been placed in permanent employment opportunities, Mr. President? And how many have shied away from reoffending? We need to get some measurable results from the peace program. We need to get some measurable results so that we can see what is happening, Mr. President. I'm not interested in that. Mr. President, what we see, because we're hardly spoken to when it comes to the peace program, like if we are against initiatives to reduce crime and to get at-risk youth off the blocks. But what we see, as I said, Mr. President, is maybe a football match here or there, a domino competition here or there, a cricket match here or there, Mr. President. So if there is deeper intervention, we would love to understand what that is, Mr. President, and what are the targets, what are the results. Also acknowledging that it is not an overnight expectation that we have in terms of results, but there has to be some record of progress in this area. Mr. President, as we are on young people, and again, the minister in his presentation spoke about gang leaders targeting our young people. Gangs target and recruit where opportunity is absent, where there's nothing for people to do, where there's no income opportunity to be earned, where there's no guidance in the home maybe. Crime flourishes where purpose is absent, where your only thing is to get up and sit down for the whole day with nothing productive to do, no direction. So what does the government have to do? Government has to create an environment where there is opportunity, where there is some level of purpose, because they have to meet those persons on the outside halfway. Opportunity has to meet the expectation of those who are looking for opportunity, Mr. President. Too many young people do not see a future for themselves, and that is a reality. Hundreds of students will leave school, Mr. President, in the next 2 months. 16-year-olds, 17-year-olds, 18-year-olds will leave school, Mr. President. Hundreds will leave the Barbados Community College and the Samuel Jackman Prescott Training Institute. Thousands will leave the University of the West Indies. We have to be able to be creating opportunities for our young people, Mr. President. We have to create, what will they do? And I am quite aware, because I know that senators on the other side, they will come and they will say what is out there. And it is one thing to have things out there, but again, it is to understand the lived realities of these youngsters, especially those that are at risk. I heard mention about the Youth Advance Corps. I heard mention about the Block Transformation Unit. I heard mention about the Youth Entrepreneurship Scheme. I heard mention about the Youth Development Program. We support programs that direct youth to productive paths, to give them purpose, to give them opportunities, to gain skills. But the reality is that there is a set of youth who need employment opportunities, who need to be able to earn an income. Because in their household, Mr. President, there is very little income coming in. Sometimes a single mother, a single father, even if there's a father and mother, the income is not adding up to even support them as a young adult, Mr. President. And I don't know what's happening these days, but I know years ago, Mr. President, I know a lot of persons, including myself, who when you get a certain level of education, although you could go to a higher level, you go and look for work to help support the household, and then you push again from there. It's just a reality. It's not everybody, especially in those communities that are at risk. Because we're talking about the communities where the at-risk fellas are, where they reside. When they look at the left and look at their right, all they can see is somebody needed help. So they need gainful employment opportunities. So I'm not saying that there's nothing wrong with the Youth Corps. I don't know what the Block Transformation Unit is doing. I understand the Youth Entrepreneurship Scheme and the Youth Development Program. But it is not only good enough to say what these things are doing. Maybe they need to be repurposed and be fit for purpose, because we have a situation now where the murder rate in this country has doubled, more than doubled. That almost every week there is a murder. And we have a situation where I think over about 240 young men have lost their lives over the last 8 years. It is not an attack on the government. It is not for the government, the senators on that side, to get up and defend the Block Transformation Unit, as I'm hearing will happen shortly. It is to really look and see if it is time to repurpose some of these initiatives. Are they really working? Can they be enhanced? Stop listening to yourselves and come and listen to the people. Mr. President, that's all. Self-reflection. But Mr. President, it's a national issue, And it needs priority, and it needs a shifting of mindset as it evolves. But I go back to the point I'm making, I think we need to get a gateway where these young people can get some employment. And we have to, the government can't do it alone, but I'm sure the government can work with the private sector to roll out a national internship program or something of the like, Mr. President. Mr. President, see that, this is, Mr. President, Senator Cummings is talking about the Job Start Plus. She has, I have heard her mention that, Mr. President. Mr. President, I am...
The only matters on which you can comment on matters made during the course of a speech. I don't think you want to open that door because every senator around here has made sort of voice comments, maybe to a neighbor, or maybe speaking to himself or herself. And I think you may want to leave that alone. Just raise the point of informing Senator Cummings, who hasn't spoken in this debate as yet.
Thank you, Mr.
Please
President. But the point I'm making, Mr. President, is that we know there are programs out there. Are the programs as effective as they can be? We have to repurpose some of these programs because the reality is, Mr. President, that the private sector is tightening for profit. The government is reducing, doesn't have income at its disposal, Mr. President, to employ these persons, and we have to find ways, Mr. President, to make it work. Mr. President, I go into some supermarkets, and I have to pay for a bike and pack my groceries myself. And 15 years ago, Mr. President, you would have some 16, 17, or 18-year-old doing that job and earning an income, Mr. President. So there are some soft things that have happened in the country that have taken away opportunity, right? And it is an opportunity for a young man to earn an income. I grew up in my household. My sister's first job was to check out. And I cannot wait on a Friday evening when she comes home with the tips to give me $20. But from there, she's a manager today. But the point I'm making, these are the small opportunities that we can seize, that we can work hand in hand collaboratively to kind of get back in there. So while the private sector may be tightening for profit, the government have limited resources and programs are put out there. I'm saying, how can we repurpose some of these, make them better, re-engage the discussion, and let us get to solving this problem of unemployment in our youth and underemployment with our youth. Mr. President, I think it can work if it is done correctly. I think it can work if we repurpose some of these initiatives. Maybe there's duplication. Maybe some of these initiatives can come together and be one and be more powerful in its execution. But clearly, Mr. President, what we are seeing as a result in terms of the murder rate, the crime rate, the involvement of the youth, we have to ask these critical questions and put some pressure at the government to address these softer issues, but important issues, Mr. President. So, Mr. President, we've established that there's support for the legislation, Criminal Gangs Prevention and Control Bill, Mr. President. The Democratic Party is on record calling for the legislation for around 2 years on numerous occasions, Mr. President. We are on record, Mr. President, feeding into the contents of the legislation, Mr. President, because when this legislation was even first brought to the lower house, Mr. President, I believe the definition of a gang, the meaning of a gang, spoke to a combination or other arrangement among 5 or more persons, Mr. President. And after the intervention of the Democratic Party, identifying that it should be 3, it was adjusted down to 3, Mr. President. But this is not a competition of tit for tat. This is just to show the hardcore facts, Mr. President, that the Democratic Party is very much present and relevant in this conversation of crime and criminal activity in this country, Mr. President. And the government must now take stock and must get out of defense mode. They must get out of defense mode, Mr. President, and work on improving their programs, on work of ensuring that the police service is at a state that it can address and respond to crime, either proactively or reactively, Mr. President. It is to manage the funds that have been at the disposal of the peace program, Mr. President, and all the other programs. It is to ensure that we get our young men, our young women, job opportunities across this country, to get them from being prime targets of lining on blocks and eventually forming or becoming a member of a gang, Mr. President. So, Mr. President, I end by, again, supporting the legislation, but cautioning the government that there are other things that need to be done. One, to make this legislation effective, and two, to help cure the ills that exist in our society today. I thank you.
Thank you very much, Senator Walters. Honourable Attorney General.
Good afternoon, sir. Good afternoon to everybody else. I rise, sir, to lend my support, and now, having heard the last speaker, to lend some guidance in relation, sir, to this bill and the overall understanding of the bill. I also want to acknowledge as well, sir, the young people who are aptly and raptly paying attention. I love to see young persons in either chamber. It shows an interest in what it is that we're doing, sir, and we often talk about young people in negative senses, but when they take their time to come and see how government operates and how the business of government is done, I think they deserve some credit for that. So, welcome. Sir, I had come with the intention, sir, of just literally running through the clauses of the bill and explaining some of what is in there, why it's in there, and why it's in there, not something else. But having sat through the last 50 minutes of the Honourable Senator's presentation, I think my time would be better served in addressing some of his concerns, because I must commend him. He started by saying that he supported the bill. He interspersed that about 4 or 5 times in there. But, sir, it is clear from some of the comments that he had not actually read the bill. And I note, sir, that I actually did a timer, and up to about 3 minutes before he ended, he had not even accidentally collided with the contents of the bill for about 26 minutes. So I wish, sir, that the Honourable Senator, having agreed and supporting the bill, that when he leaves, sir, he's in a position to actually explain to somebody else what is in the bill so that the public can actually understand and support it as well. So I'll just address some of his concerns. And I will start with concern number 1. The Honourable Senator, sir, almost sprained his arm trying to pat himself on the back by commenting on the fact that the Democratic Labour Party, and these are his words, we, the Democratic Labour Party, want to make crime a political issue. And I think that's the problem. That is the problem with the approach. That's the problem with what was said.
You said that?
You can call for an answer. I wrote it.
You said that, yeah? You said that. You said that. As the AG.
Sir, with your leave, sir,
Please press on.
I tend, sir, to debate across and not down. Sir, the exact comment made by the Honourable Senator, and I could not believe it was actually said, was that we, the Democratic Labour Party, want to make crime a political issue. And he then went on to talk about the fact that they did their own committee, and they produced 100 and something pages, a lot of pages, sir, 148 pages, and sought to pour cold water on the Advisory Committee on Citizen Security, sir. Now, I do not know if somebody is actually really interested in Barbados, why would they not participate in a national effort that had all of the relevant stakeholders there so that the fullest possible perspective can be gained and the maximum benefit achieved by the exercise? Why would you pat yourself on the back because you went off and conferred among persons of like mind without having engaged others? Now, sir, what is even worse is that the Honourable Prime Minister took pains. She said, when she created the committee, this has to be a whole of government approach. Crime is a whole of government approach. She said, I remember clearly, people must be free to go to the supermarket without fear of being robbed. People must be free to go and buy pudding and sauce on a Saturday without being in fear. They must be free to participate in all things reflective of Barbadiana without being in fear. And for that to happen, we had to bring together pretty much all the social partnership, all the stakeholders, everybody who had something to say about crime was free to come and say. Everybody. The bar was involved. Even persons who had been convicted were invited to come and make their comments and give their perspective. And the Democratic Labour Party was invited. Every other organization that was invited, every sector that was invited put forward somebody, even the ex-convicts, but not the Democratic Labour Party. So if the Honourable Member wants to make crime a political issue, then I suggest he goes ahead, because the public of Barbados already took note of their position on it and made their comments and their position clear in February. No, sir. The Honourable Member also said that the problem with the bill is that there are no short-term or medium-term solutions. There are no short-term or medium-term initiatives or impacts. But then about 4 or 5 times in the course of his speech, he said that we know this can't be done overnight. We know it's a process. Now, had the Honourable Member read the bill, the Honourable Member would realize from the tone of the bill that this bill has the most severe sentences of any piece of legislation in Barbados. The most severe sentences, minimum sentences, not one cropping up somewhere in the bill, not 2 cropping up in the bill. Almost every single offense under this bill is attended by a minimum sentence. That's the government saying, we have heard Barbados. We have heard the cries of the people. We have heard the cries of the opposition. We accept what is going on and recognize it. And we are now taking steps to deal decisively with this and to send a message. Now, sir, I don't know if somebody facing a minimum jail sentence of 10 years for almost everything under here, and when it isn't 10, it's 15, and when it isn't 15, it's 20. And these come into operation immediately, sir, on the proclamation of this bill, when the act is passed. So if that is not addressing it short or medium term, then, sir, I don't know what is. The other issue is the comment was made that, and the last half of the Honourable Member's address was on all the other things that should be done, that this needs some, I support it, but it needs more teeth. I support it, but it needs other things to be more effective. Sir, I point with pride to the social programming of this government. This government has instituted more social programming, more social initiatives, more initiatives to help poor people, vulnerable people, the disadvantaged, the disabled, everybody than any other government in the history of Barbados. I'm not going to call all, I'm going to pick some, because the honourable member actually did call some. He said he could go a bit further, but he did call them. So the Chapman Challenge, which is spearheaded by the President of Barbados, no less a person than President of Barbados, sir. The peace program that the honourable member said needs to be revisited, the fact is it exists. You can only revisit and upgrade something that was actually instituted. The social programming, sir, the legitimate clubs, the trust loan program where the government said, for those who nobody wants to back you, we can back you. You back yourself, we can back you. We will lend you initially, it was up to $5,000 on the first instance, $10,000 on the second instance. But now you're starting at $10,000. 20,000? Up to 20,000, sir. If that is not the government backing its citizens, I don't know what is. Sir, the One Family Program, the Construction Gateway, the $5 million to faith-based organizations to intervene in situations just like this, to provide programming and assistance to help and give options to disadvantaged persons. The Youth Advance Corps that was raised. So I can actually do my whole speech and use up my whole hour just by calling out programs that the government has done. But that's not a good use of my time, sir. So sir, the point is, sir, everything cannot be covered in one piece of legislation. This is not a standalone in relation to the policies or the attack of the government on crime. This is about one tool, sir, in the arsenal to fight crime. So when the question was asked, and the question was asked in good faith, the question was asked, sir, as to why not include provisions or create a nexus between the instrumentalities, proceeds instrumentalities of crime and whatnot. So this is not that. The fact is that stands alone. If you want to trace funds, if you want to track and seize assets, if you want to destroy the proceeds of crime, there's legislation to do that. It doesn't have to be in here. This piece of legislation is concerned solely with gang and gang-related activities. The honourable member talked about dismantling gangs, but if we look at dismantling gangs, the first thing this does, and he talked as well about the targeting the heads. He wanted the head of the lizard. I never heard that analogy before, so I always thought it was the head of the snake and the tail of the lizard, but we will meet him where he is. He wants to go after the head of the lizard. But if you look at the legislation makes a distinction between a member of a gang and a leader of a gang. The leadership of the gang attracts a harsher sentence than being a member or an associate. If we're talking about associates, the question was also raised by the honourable member as to the use of the word associates or association, and that somebody, that they're crowded communities and people may be out, and just by virtue of the fact that you lame him as somebody, you get caught up. That's because, sir, the honourable member did not read the definition. I go again, sir. We are here today for the Honourable the Senate to debate, sir, the content of this legislation. Somebody who comes in here trying to debate what somebody else said in another place without having read the legislation, sir, then that speaks volumes. But let me, as I am on the path, advise. Sir, what is a gang? As I'm here. Sir, in this act, a gang means any association, organization, group, alliance, network, combination, or other arrangement among 3 or more persons, whether formally or informally affiliated or organized, and whether or not operating through a body corporate or other association. That, and the number 1 qualifier, it says 3 or more persons that engages in criminal activity. So criteria number 1 is that you have to engage in criminal activity. If you happen to hang out with your friends on a corner and you don't do nothing illegal, this does not apply to you. it applies only insofar as the three or more of you engage in criminal activity. And I thank the honourable member for his support and actually claiming that the decision to revert to 3 was due to the instance of the Democratic Labour Party. Now, I thank him because when we initially drafted this legislation, we drafted legislation having 3 persons. Because the Trinidad legislation aims at 3, the Jamaica legislation across the Commonwealth points to 3, Bahamas. But we, in our discussion, said, based on historical factors, we felt that the Democratic Labour Party would object to it being 3 persons, would say the threshold is so low, and if it's 3 persons and 3 of you hanging on a corner, it might catch you. So out of an abundance of caution, we started with 5. We went to 5, saying 5 is a nice round number. Sir, we went through a number, we went back and forth on a number of points that we actually thought might cause contention. Then, upon consultation with the Bar Association, and we also passed the legislation by the judiciary, because at the end of the day, when we pass it, they have to apply it. So any comments from them will be welcome. And the comment was made that if we're dismantling gangs, let's not start with 5, because you have to pass 3 to get to 5. So don't wait until there are 5 persons associating. Try to catch them at 3. But equally, if the threshold is 5, you have a harder time proving that the 5 persons were in the gang than you would with 3. The burden of proof is a lot smaller, a lot easier to achieve if it's 3. So we went back to 3. So I'm glad, sir, that we had him on that, although not for the reasons that the honourable member thought. But then, sir, even the stop clock is right twice a day. So at some point in time, we have to be on the same page if we are all interested in Barbados. So that's the reason we went with 3, sir, and not 5. So that was the gang, okay? Now, the honourable member also spoke about associates. The reason we went with associates, because the legislation as initially drafted did not actually have associates in it. But because of experiences in other Commonwealth territories and their difficulty in proving gang memberships, because some gangs, sir, require an actual ceremony or an actual initiation to qualify as a gang member. You have to go and do a crime that qualifies you as having earned your stripes. You have to be involved in some actual initiation. Where the initiation cannot be proved or the initial criminal activity can't be proved, then it's hard to prove the membership in the gang. But do we want a specific person who actually went and took a step to initiate, or do we want persons who are associated with? So because of the jurisprudence in other countries, because of some comments by attorneys who practice criminal law, and also due to some invaluable comments by members of the judiciary and former judges, associates was included in there. So a gang member, sir, includes a person who belongs to a gang, engages in gang-related criminal activity, or associates with a gang. And gang-related criminal activity means the activities listed in the schedule. I won't go through all of those, right? But effectively, if I choose to hang out with 3 people I know belong in a gang, I know they're up to no good. I associate with them. I roll in the car with them when they're going to rob somebody. The fact that I did not form the gang, join the gang, does not exonerate me. The fact that I willingly participated, although not being a member, catches me in this legislation. For example, sir, it's like somebody who wanted to join the Democratic Labour Party. They once looked at them, thought they were a viable organization, and said they want to be a member. But based on recent form, they're rethinking that. They haven't signed the membership form, they haven't filled it or submitted it, they haven't been approved. I don't even know what the approval process is, but they haven't been approved. But they hang out with them, they roll in the same car with Senator Walters. They roll with him and some of his other friends. They go out and have a drink with him and the Honourable and other people. The fact is, although they have not signed the form, people can say, look at them 3 Dems. Guilty by association. That is why, sir, associates is included in here. Now, sir, I have trouble forming the numbers for gang. Sir, but as was said by the Minister of Justice, sir, a provision in here, there was a concern, a great concern in relation to people stigmatizing and targeting people based on where they live. So the decision was made in here directly to have a provision which says that where you live or the community in which you live cannot be a factor in whether or not you're a member of a gang. So it's not evidence. So don't care where you live. You are not caught up in this. It's not where you live, it's what it is that you do. If you live somewhere and you choose to, that is normally associated with crime, but you carry yourself above that and you live your life the right way, you will not come into collision with this. If you live in the heights and the terraces and you live in Sandy Lane, but you choose to go and roll in the car with the 3 usual suspects, then you will be caught. So where you live is not a factor. Now, sir, I'm going to take, recruiting was mentioned by the Honourable Member, and to get back to the Honourable Senator Walters' presentation, he said you need to dismantle. The dismantling is attacking the gangs at every single level of gang relationship. It's attacking them for recruiting. It's attacking them for recruiting children. It's attacking those who harbor them, those who facilitate them. It's attacking those who help them after commission of a crime. And we are protecting the most vulnerable. We accept that we have to look out in particular for our children. That is why anybody who recruits somebody to a gang, right, who recruits a child to a gang, sir, is liable on indictment to a minimum of 10 years and not more than 25. For the purpose of getting through quickly, I'll just go 10 to 25. Everybody knows what that means. Liable to 10 to 25 years. However, if you choose to go and target school children or children in a place of worship, then you're looking at 15 to 25 years. Now, when we had last dealt with this, there was a misconception that was reported in the press that I indicated that where someone is in loco parentis or someone is a parent of a minor child who they're harboring, that person is exempt from the provision of this legislation. No, the person is not exempt from the provision of this legislation. The judges have to apply the minimum sentences, the mandatory minimum sentences. They have some leeway, but they have to give the reasons for it. I'm going to touch on some of the criteria, but the only place it differs slightly is if you are the parent of a minor child who is a gang member or a gang leader. What can mitigate on your behalf that does not operate for anywhere else in the legislation? You will probably still, sir, find yourself on the wrong end of it, but it is a mitigating factor, any attempts that you made to actually bring your child onto the straight and narrow. Right? But with the exception of that, all of the provisions apply to a parent in the same way as they apply to anybody else. Now, sir, for those who know legislation, when their minimum sentences, mandatory minimum sentences were deemed to be unconstitutional, and that came out in relation to death penalty cases. However, where the legislature feels to guide the judges by saying this is what we expect the mandatory minimum to be, it has to allow them the out to exercise their discretion. Now, the out is normally for serious criminal offenses if the person is under 18 years old, or if the person was a first-time offender, or if public safety and public order will not be prejudiced, or the court finds other exceptional circumstances. Sir, we have put our foot down with this one. So it is not a matter of ours anymore. For the judge to exercise their discretion to come below the mandatory minimum, the person has to tick all of the boxes. The person must be below the age of 18, and this must have been their first offense, and public safety and public order will not be prejudiced, and there are other conditions that the judge feels should be taken into consideration. So this is a vast departure from probably any other provision, similar provision in the laws of Barbados, because they try to give you out on one. If you take off one of those boxes, you tend to get the out. Because we are so serious about the anti-gang legislation, the criminal gangs legislation, it's not ticking one of the boxes, because we also acknowledge that a lot of the persons perpetrating crimes in Barbados are minors. 16 to 24, I think, is the catchment area, but a lot of violent offenders who are between 16 and 18. So if you're between 16 and 18 and you have committed an offense before, don't expect any leniency with this. You will get the full sentence by virtue of having not been a first-time offender. So the under 18 is not helping by itself. It has to be under 18 and clean, and the offense is not one that will pretty much outrage the public. So I just wish those who need to know and need to hear, because quite frankly, sir, the sentences under this are militant. The sentences under this are decisive and severe. For an offense under this legislation, the average person is looking at a jail sentence of a minimum of 10 years. We tend to drift in to different sentences, sir. So, for example, we adjusted this slightly to address a situation that arose recently. So persons who use bulletproof vests or law enforcement paraphernalia or defense uniformity of the Barbados Defense Force, you're looking, in the commission of offense, you're looking at 10 to 25 years, sir. 10 to 25 years straight. So camouflage, if you wear camouflage and go and commit an offense, you're looking at 10 to 25 years. Sir, the honourable members, the Minister of Justice spoke previously about harboring or concealing a gang member. For all those who feel that passive acts do not count, passive acts in this count, if you know that your friend is the most wanted and you choose to let him hide under your cellar, if you are found guilty of that, sir, you will go to jail. If you conceal gang-related activity, you will go to jail for 10 to 25 years. Sir, they even get on to letting people use your vehicle. Sir, the other thing, we've all known the situation, sir, where people tip off. You know something happening, you may have been in a police station and you see the tactical team gearing up, and you see a whole set of vehicles leaving, and you might have heard somebody say, Ryan Walters. And you make that phone call to advise the person that the police leaving and coming by you. Tipping off, sir, 10 to 25 years. The question was raised as to, does this affect attorneys? Because there's a penalty for counseling as well. If you advise persons how to engage in their criminal activity without being caught, that attracts a sentence as well. Well, the issue was raised, does this impinge upon the professional rights of an attorney at law or your right to counsel? No, sir, we addressed that because somebody can ask it. Nothing in this section nothing in the act makes an offense for an attorney at law to disclose any information or matter or to a representative of or his client in connection with the giving by the legal advisor of legal advice to the client or in contemplation of legal proceedings. So you, the lawyer, you are free to give legitimate legal advice to your clients. You are not free to warn them or advise them how to better conduct their criminal activities. So if you, the lawyer, abide by your professional ethics, this does not concern you and you don't collide with this. Retaliatory actions in particular, sir, have attracted sanctions under this, because we know a lot of the violence, as the Honourable Senator Walters said, you know, it's tit for tat. You hurt me, I hurt you. We go backwards and forwards and we trade bullets. Sir, retaliatory actions. A person shall not intentionally take retaliatory action against another person or relative, friend, associate, or property of that person on account of the other person refusing to be a gang member, ceasing to be a gang member, refusing to render assistance. It's all said over here, giving information. So if they say snitches get stitches. So if I advise the police that I know gang activity is happening here, somebody takes it out on me for doing that, sir, you're drifting into the more severe sentences. That's 15 to 30 years for retaliatory actions. No, sir. I'm coming to the end. In terms, we have to protect those whose job is dangerous. Judges, magistrates, prosecutors, jurors, they are at the business end of criminal activity. They are at the business end of trials. So we have to protect them. If you tamper with a judicial officer, intimidate a judicial officer or a juror, you're looking at 20 to 30 years. Your starting point for intimidating persons involved in a trial is 20 to 30 years. As we said, bail, sir, under this is bailable by the High Court only. And one thing, sir, we have here the consideration of power to vary sentences. And we have given I explained about the variation that you have to tick off all the boxes and whatnot. But it also, sir, does something that is a new introduction to legislation. Where the court imposes a lesser sentence than that prescribed for the offense, the court must give reasons for its departure. So we are now putting the court, sometimes you see sentences, you say, well, how did the judge get there? Right? You hear people saying, well, how does somebody get there? If a judicial officer comes below the minimum sentences, they have to give reasons for it. The giving reasons means that the state can now do something we're not accustomed to doing. We can actually appeal the sentences. Normally, appeals to sentences are by the convicted person who said that my sentence was too heavy and appealing the heaviness of the sentence. If the state believes the sentence was too low and the reasons were not valid and enough boxes weren't ticked, the state can actually appeal that as well because the judge has to give the reasons. So we've made a serious departure, sir, into addressing the realities of the situation, the realities of the gang situation in Barbados. And we're sending a message at the end of the day. We are sending a message. We are not playing with you. We have heard Barbados. We've heard the opposition. We've heard the public. We live in the communities as well. This is as serious as it is and as hard-hitting as it is, because at the end of the day, this is being done to protect Barbados and to protect Barbadians. Bajans must feel comfortable going about their business, and we, the government, have a duty to make sure that we put the framework in place to secure that comfort for you and anybody who breaches it, that the framework is in place to allow the law to do its job and allow you to pay the penalty and serve the time for the crime that you've done. Now, sir, I entirely support, well, I don't get to vote, but I hope that I have done, and those who are here, sir, have a better understanding of the content of the legislation and are better informed. I thank you, sir.
Thank you, Honourable Attorney General. Senator Cummins.
Mr. President, I beg to move the suspension of this sitting of the House until 3 p.m. in the afternoon.
The question is that the Honourable Senate, suspended until 3 p.m. today. Will those Honourable Senators in favour please say aye? Those against please say no. The the ayes have it. The sitting of this Honourable Senate is therefore suspended until 3 p.m. today.